two, 1, 2. 1, 2. 1, 2. 1, 2, 1, 2.
Good morning, everyone. It's 10 o'clock according to my laptop. I can't see I think it seems to coordinate with the clock, so that's good. So this hearing is now open. So first of all, can everyone hear me? Is that fine? Thank you. And can I just check the way these microphones work? Do I need to knock off for someone else to speak? Might take us a little while, but we'll all get used to it. Yes, thank you very much. Okay. So is everyone comfortable as well in terms of the room, etc.? So before I take introductions, I should say, you'll probably have noticed that this event is being live streamed, and it'll be available as a recording on YouTube. Now I can see that the camera, I think when we had it set up before, it's sort of facing more in this direction. Is anyone uncomfortable with being recorded? Because we'll move you around if there is, so you're out of. Okay, thank you very much. Okay. So if you can't hear anybody, including myself, through the course of the today, please do let me know as soon as you can, just by raising your hand or waving if you've stuck your hand up and I haven't seen you, because obviously there's a lot of things going on today, and just so we can make arrangements so no one goes away unhappy. Could I also ask that everyone switches off their mobile phones or sets them to silent, and also with your IT equipment as well, if just make sure just to avoid any annoyance for anyone. My name is Mrs. Dillon, and I'm a Chartered Town Planner, and I've been appointed by Secretary of State to hold this hearing. And this is to determine the appeal that's been made by Kellen Developments. Now, Mr. Bartle, who is the case officer for this appeal, is based at my headquarters at Bristol, and he will remain your point of contact throughout the remainder of the appeals process, just to clarify that. Now, I'm not expecting any fire alarms or drills to be happening, so if they do, we'll have to take it that they're real. And all I would say is we've got signage that directs us out. We have colleagues here that are familiar with the building, so I'm sure that you will all. I'll just let you sit down. Yes, I'm sure that they'll get us out safely. And all I would say is just remain calm and collect what vital elements you need, but don't stop packing up your IT equipment, etc. Because obviously we need to get out as quickly as we can. And we would just convene, I think, at the front of the building and await further instruction, but hopefully we won't need that. I noticed that there was some noise earlier on. I think you said you were going to try and resolve. Hopefully it's something within your control.
It is not, I'm afraid, ma'am.
Right,
It is the adjacent restaurant unit.
Right, okay.
So we have requested that the noise ceases.
Yes.
That's the best that we can do.
Okay, we'll just have to see how that goes through the course of the day. These things are sent to try us, so we'll persevere with it and try to get through today. Now, is everyone happy in terms of COVID sort of considerations? Because I know that we're now in a world where we just need to really all be exercising our social conscience. I've certainly done that, and I'm confident that when I tested, I wasn't infected, and I'm just hoping that everyone else is sort of got the same type of conscience as me. But if anybody feels uncomfortable and wants to wear a mask, by all means you can do. There's hand sanitizers, and I think we're all sort of familiar with the drill now with this type of thing. Now, I understand the toilets are back along the corridor in that direction, just through the double doors. I think there's a key fob system, and I don't have a key fob, so we.
To be unlocked,
right, okay. So.
Everybody needs access then.
Right, okay. And what we will do is, if anybody doesn't come back after a long period, I'll send somebody out as a search party for you in case you get locked out. And if I get locked out, we won't get any further, will we? So, so there you go. In terms of IT, I understand the Wi-Fi is complimentary and it's a PCC guest. And the password for anyone who needs it is Sand Martin, all lowercase. I've just been alerted from my headquarters that I have an IT update, which might well affect the stability of my tablet. If that happens, I'm sure it'll only be for a short period of time, so I might need to sort of adjourn just while I fiddle on with that to get that resolved. Hopefully it won't, though. I do have a lot of stuff backed up on my desktop for such eventualities anyway, so hopefully will not be. So I think, right, back to the purpose of this hearing, really. So the appeal that I'm considering results from the failure of Peterborough City Council to make its decision within the prescribed period set by government for determining planning applications. Now, it's for an outline planning application, and that's described as construction of up to 14 prestige self-built dwellings and associated infrastructure with access secured, but with all other matters which include appearance, landscaping, layout and scale being reserved for future consideration. So it's about establishing the principle of development, and if I was minded to allow the appeal, the appellant would then need to secure the reserved matters from the council. And that's at a field to the east of Old Pump House, Old Leicester Road, Wansford, Peterborough, Cambridgeshire. Now, I hope I've pronounced all of those words correctly, not coming from this part of the world, so I think I have. So, but do correct me if throughout the proceedings if I do mispronounce anything. Now, is that everyone's understanding before going any further? I'd hate to think there was somebody sitting in the room that is thinking, no, I'm not here for that purpose. No, always good to check. So there are some important formalities that I've got to attend to first of all. So it might seem pretty boring for some of the observers, but it's critical from a procedural point of view that I do this, particularly given that as well as determining the appeal, if I was minded to allow it, I would also be granting planning permission, because that's something the council hadn't made its determination. So it's a twofold process for me, which is slightly different to when the council refuses permission. So in terms of the participants, I'll start with around the table first of all. I'd just like your title, who you're representing, your position, and and qualifications if you want to give me them. But bear in mind, I'll be scribbling down. I'll begin with the appellant first of all, and then we'll lead on to the council, and then any interested parties who are wanting to actively participate, or who think they're going to actively participate in it. Obviously, as we go through, if you have sort of not indicated that you want to participate and then you suddenly change your mind throughout the course of today, just let me know and we can sort something out. So if I just begin with, get my pen and paper, and we'll begin with the appellant first with just introductions.
Thank you, Madam. My name is John Hunter, John, Hunter spelled the normal way.
Yes.
I'm a barrister and I'm instructed on behalf of the appellant by Pegasus Group. Oh,
Sorry.
apologize.
Beg your pardon, because I can hear you. Do I need to?
Oh, the speak button. I apologise. I'll repeat that again, Madam, for those who didn't hear. My name is John Hunter. I'm a barrister instructed on behalf of the appellant by Pegasus Group. Thank you.
Morning, Mum. I'm David Hutchison from Pegasus. I'm an executive director. My qualifications are set out on the front of my hearing statement, so I won't repeat those, and I'll be dealing with planning policy matters.
Good morning, ma'am. My name is Mark Henderson. I'm a principal planner, also from Pegasus Group, and I will be dealing with housing land supply.
So, okay, I'll now move to the council. Thank you.
Thank you, ma'am. Yes, my name is James Croucher. I'm a Chartered Town Planner and I'm the author of the Local Authority's appeal statement, and I'll be representing the Local Planning Authority.
I'm Gemma Wildman, Principal Planning Officer at Peterborough City Council, working the local plan team, so I'm dealing with the 5-year land supply issues.
Okay, thank you. Now, is there anybody here in the audience? Yes. So I don't know whether...
Thank you for allowing me to speak.
Now, can I just check? You're obviously representing the parish council, and are you representing anybody? Is anybody else? Is it yourself and represent yourself? Or are you speaking?
Myself, I'm representing the parish council.
Yeah.
My personal views are not expressed in this hearing.
Okay. Now, do you want to clarify at the moment which parts of the agenda that you're going to be most interested in?
It goes back to when the first application was made, and the parish council did object to that plan application, and we still do.
Yeah.
So it's basically on the village envelope. It's outside the village envelope.
Okay.
And the adverse effect it could have on the triple SI.
So probably the most relevant items for you are probably item 3 and item 8 are probably the most, if that's what I'm understanding correctly. Well, what I'll do is if you want to, when we come to bits, if you need, I'm quite happy for you to sit where you are, but if you want to come to the table so that you can use the microphone when if there's anything that you want to say, we'll just deal with it at that point.
If everyone can hear me, then
Yeah.
I'm comfortable.
Yeah.
I will stand.
All right, okay. I think we need to use the microphone for the streaming. So
Okay.
yeah, so I'll let you. There'll be a chance later on for you to swap around. So that's
Bear with me with that one.
okay. Then thank you. Is there anyone else here today that's wanting to actively participate? Okay, and as I said earlier, if that does change throughout the course of today, then just let me know as soon as you possibly can. Can I just check we're not expecting anyone else? No, everybody's here. And have we got any members of the press here today? No, thank you. So once I've finished my opening, we'll lead into a structured discussion, and it's important that everybody realises that I'll lead that discussion. And I'll just check first of all, does everyone have a copy of the agenda that was dated the 11th of November? I think there may well have been a delay in it being circulated to everybody, so I apologise for that, but it had been drafted on the 11th to go out there. Try to stick to that agenda, but we might well find, I think particularly with how, I've got some thoughts around how we deal with house and land supply that I'll talk about a little later, so it might be that we flip a few things around, but that just gives us a structure. Now, the purpose of today is to give all participants the opportunity to put any points forward. It's not there for you to repeat in verbatim any representations that you've previously made. It's really to try and move things on a little bit as well. And this will ensure that I've got all of the relevant information that I need, and importantly, that I go away with a clear understanding of of everything, so that I can make my decision. So through the course of today, I may well be looking down and taking notes. I may be looking at my screen. I may be looking at hard copies in my folder. That doesn't mean to say that I'm not listening to anybody, so just so you know. Now, I'll continue talking. Can you actually hear me? Okay, so I'll try to persevere through and see where we get to. So, what we need to do is to focus on the material differences between the parties and the clarifications that I have. I've read all of the written statements and the representations, and I'll be rereading them several more times before I make my final decision. So there's no need for us to listen to sort of repeat material, but you can draw my attention to something specific that's in your evidence where that's relevant and where it's going to be helpful to me. Now, I'm going to be inviting contributions from one side and then the other, and then also from interested parties. Please answer my questions as clearly and as concisely as you can, using the microphones that we've got. And we'll just have to make sure that everyone can continue to hear. So please don't be shy if there is a point, either you can't hear me or someone else, particularly when we've got this noise going on in the background. And rest assured, I'll give everybody an opportunity to address, to have their say if they've got the hand up. Assuming it obviously we need to stick to relevant points. And if you feel that I'm moving on before you've had your opportunity, then again, just let me know. And importantly, if anyone becomes unhappy throughout the course of the day, please let me know so I can do something about it. It's certainly not the intention. So please do let me know, because I can't do anything about it after the event. Now, having read the submitted evidence, the main issues for the appeal seem to be centred around. I've got 5 points. I mean, there's obviously there are other matters that are there, but the main ones are whether or not the provision of new homes in this particular location is justified, and that's with particular regard to the area's adopted spatial strategy and the current house and land supply position. It's also about the contribution that the appeal proposal makes to meeting local housing needs, and whether or not the appeal proposal makes effective and efficient use of land. It's also about the effect that the appeal proposal will have on the character and appearance of the area, and the effect that the appeal proposal will have on local ecological interests. Now, I realise that since the appeal was lodged, the main parties have reached common ground on the disputed ecological issues. I do have some questions on that matter, which we'll come to later, and you should have received an email, I think, that tipped you off that although there is common ground, it's something I wanted to make sure that people were ready to be able to discuss any points that I've got, so that's good. What I hear today will assist me in determining whether all of those issues remain the main issues, or indeed whether or not there are any issues that have been raised that need to be elevated up to main issues. So it's by no means fixed at the moment. So you'll see from the agenda that I've tried to sort of unpick unpack the main issues a little bit further into the components that we've got, and that's why we've got like we've got six points, and there's a little bit of overlap between some of the things. So has anyone got any questions so far? Is everybody content with the scope of the agenda and the scope of the what we're thinking are the main issues at the moment? Okay. Now, I am concerned to make sure that everybody remains engaged and we don't all go home with a headache. So I'm going to continue on with my opening, and we'll start going, and then we're going to have to see where we get to with this with the noise issue. Now, we'll have a lunch break. We'll have a quick, probably mid-morning break between items, and we'll try to fit one in the afternoon as well. But if you feel an adjournment would be useful at any other time, please let me know, and we'll just work together to get. Now, we've got this room booked until 5:30, and depending on how we deal with some of the matters, and particularly housing and land supply, I'm hopeful that we will manage to cover everything. Although it is quite a big agenda that we've got. I'm working on about 30 minutes, I think, per item to get all the way through today. When you divide everything out, but that's on the basis that we've got sort of an extra 30 minutes that we could devote to something like land supply, one of the main points if we need to. We may find that we need to take a view on where we go if we don't get far enough through today. I think we're going to know where we are by about lunchtime. There's the opportunity for, it's not ideal, I'd usually like to get all the way through, but if situation and circumstances are such that we have to adjourn, we'll have to do that, and that we can look at how we then resume at another date. Now, it's crucial in the interest of openness that before, during and after the hearing, I'm not left alone with any party. So when we adjourn, just let me leave the room first so that everybody can be certain that I'm not hearing or seeing anything that I shouldn't be. Now, I do have a retiring room, which is just on the other side of those screens there. I can hear noise, but fortunately I do have some hearing issues at the moment of my own with my ears, and therefore I can't really decipher what anybody's saying. So, but just to let you know that in case anybody's sort of speaking loudly, I might be able to hear. I would come straight out and tell you though. And you can, by all means, you can stop in the room through the breaks if you want to. But the important thing is that we all rejoin before the stated time, and that's so that I can then come back in. It's the same in particularly the lunch break. If we come across each other in the corridor, I can't stop to speak to you. It's just the way that things are. Okay, so I just want to now go through the notification letters and representations. There's been a bit of communication between the case officer and the council on the notification letters and representations. It's important that I'm satisfied that everything was done at the correct time and in the correct manner. I do think that I've now got the clarification that I need. So I've got a copy of a press notice dated the 6th of July 2017. So this was for the planning application. I understand that a letter dated the 27th of June 2017 was sent to neighbouring properties, and I've got a sample of the wording that was used. I don't have the original letter, but I also have letters from interested parties that refer to the letter of the 27th of June. So I'm confident that that letter did go out, even though I haven't got that. I've also got a photograph which shows the council's site notice in situ. I wasn't able to clearly decipher. I'm confident that it was the right notice posted, and you've provided a sample of what that site notice said. And from what I can read, it was really the date that I was struggling with to read. And I knew it was the 20-something. I just couldn't work out whether it was an 8 or a 9. But anyway, I think that there's sufficient evidence there now before me to demonstrate that that site notice was undertaken. And we did have got representations from interested parties. So that does demonstrate that people were aware of it. Now, I just want to check, were any subsequent submitted plans or documents that were submitted through the course that you would determine in the planning application, were they subject to any further consultation?
There were selected consultations to a number of statutory bodies, including Natural England, at the time of additional ecological information, ma'am, yes.
Okay. But nothing in terms of interested parties?
No, that's correct, yeah.
And can I just ask, are you confident that the application has been undertaken in accordance, the publicity has all been undertaken in accordance with you should have a statement of community involvement or something that...
The council is satisfied, thank you, ma'am, yes.
Is there anybody here that wishes to say otherwise before we move on from that? Okay, thank you. And obviously you're here today, so you're aware of it. So something worked somewhere along the line. Now, in terms of the appeal, I've got a copy of the council's letter dated the 1st of April 2022, and along with a list of the people that were notified of the submission of the appeal and how they could submit their representations. And I've also got a copy of a letter dated the 7th of November 2022, which notifies the same list of people, the time and date of this hearing. And I've got a copy of a follow-up letter which advised those people of the live streaming arrangements. So I'm satisfied again that, and we have people here today as well, that's all in order. So I think the rules for hearing procedures have all been met, so I am happy to continue on. Now, in terms of representations from interested parties, I'm in receipt of written submissions from 23 people. Some of them are double up people, so I haven't done the maths on that. I'm more interested in what they're saying, and they've been made at either the planning application or the appeal stages. And just to reiterate, today we'll be taking those as read. But I would like to just check with the council. This might be something I'll have to ask you a question. You might have to get somebody to go away and check this, or you might know off the top of your head. There's a representation from the occupiers of the old pump house. And that is Rep 5, I think it's listed as on the documents that I've got, in terms of the way the PDF's been saved. That refers to a disc that was included with the written submission, and I just want to check that. I mean, obviously I don't have that disc and it's some time ago. What I need to know is whether or not there's anything on that disc that isn't in the representations that I've been given.
Thank you, ma'am. I will come back to you on that before the end of the hearing.
Yeah, thank you. And if I could have that badly, but are you clear what I need? Yeah, thank you. Yes, please.
We've got several hours of it. There is another room free if you do want to use another room.
Okay.
It's quieter. The council chamber is empty.
Right.
If you did want to move, it's possible to do so.
Okay. I think we might, well, if this is going to continue, and I think once I've done my opening, I feel as if we should move, because it's going to affect my concentration. I know that. Okay. Okay, thank you very much. If that's going to right, okay, thank you for. But we'll just continue with the opening if everybody's comfortable with that. And if you can all hear, that's fine. So you're clear that we need that. I just need that that clarity there. Is there anything that the council wants to say about the publicity before we move on?
Nothing, thank you, ma'am.
Okay. Anything that the interested parties want to say about the publicity before we move on? Appellant, no. Okay. So in terms of the evidence that I have before me, I set out with my pre-hearing note, which was dated the 18th of October 2022, to the main parties, that all of the documents and evidence should have been provided at that point. But I appreciate that there being a passage of time, and that for reasons unknown to me, the appeal has been, it's been in our hands for a while, not in my hands, in the organisation hands for a while. And then obviously I was picking that up, conscious that there was a passage of time. We had a house and land supply, something that moves on, etc. So I asked if you'd both review your evidence, and that's what you both did. Now, just as by way of this is just so that I know that I have everything, and I know that you all are aware of everything as well. I've got a statement of common ground, which was signed on the 8th of November this year. And that was signed by both parties. Now, in terms of there's been email communication about a housing land supply statement of common ground. And yesterday, I think it was late on yesterday, I received an unsigned version of a house and land supply statement of common ground, and that's the latest version I have. I haven't given it any, because I haven't decided whether or not I'm going to accept it, because I need to get to a point of understanding where we are today with it at this point in time, and how things are going to move forward, and then I can make my decision. Obviously, from my perspective, a statement of common ground is a very helpful item, particularly for matters such as house and land supply. So it would be helpful if we do have, if we can have one. So, but I'll check a little bit later once I've got through this list of where we are with that. Now, I've also got a revised house and land supply position statement from the council, and that was received on the 31st of October of this year. So that's what updates the previous evidence on the house and land supply, and that can't be helped with the passage of time. And again, it's something that I've accepted to the in the hearing. And I've given the appellant opportunity to comment on that, because that's only fair that that happened. Obviously, I appreciate there was a very short window of time for all of this to happen, and I appreciate everybody's help and assistance in trying to deal with it in a timely manner. So I'm confident that you've seen that, appellant, because you've prepared a rebuttal and an appendix 2 in response to that. And I received that on the 17th of November this year. I've seen an email that the council were copied into, so I am assuming that you have seen that. We'll call it it's an addendum to the original appellant's original housing evidence.
To confer with my colleague for just a second, ma'am.
those yet.
It was, sorry, yeah, Joe.
Wednesday or Thursday.
We have seen those, thank you, ma'am. Yeah, we have, thank you.
Thank you. Now, because of the timing that came in, and that's no, it's just a sequence, isn't it, of the housing evidence being updated, but was having a fixed window of time, and then everything that needs to be done within that. I'm conscious that the council haven't had an opportunity to respond to that, and then for you perhaps to consider that. That's something that we need to work through today to decide how best to deal with that. So I think what I'm going to be wanting to establish is, and I'll give you a little bit of time to think about the answer to this, but just so I plant the seed, I'm going to be asking you later on whether or not you're happy to continue with the housing land supply discussion today, given that I haven't had a written, you weren't given a big opportunity to comment on that new evidence. I know the appellants tried to keep it to a minimum, and we've done it as like an addendum rather than a new statement. But if you just have a think about that as to how we're going to progress, because some of the matters could be perhaps verbally addressed, but I'm conscious that I want to be fair, and it's a complex matter that needs the appropriate attention, because obviously it's going to have a implication potentially on how I deal with the appeal in terms of the framework, as you're all aware. So it does, and the implications on potentially on policies, etc. So it is so I'm going to leave that, and again for the appellant as well, have a think about that, and we'll park that issue, and we'll just get on with a list of what I've got, and we can think about it a bit more later. Now, I've also got an agreed list of planning conditions, and that was dated the 8th of November this year. That I understand that that's an agreed schedule, and I'm not aware that there are any points in dispute in regard to the wording of those conditions.
That's correct, ma'am.
And that's including the pre-commencement.
Yes.
Okay. I've also got a signed unilateral undertaking to deal with planning obligations from the appellant, and that's dated the 15th of November this year, and that includes a couple of plans which are coloured. I can read them, the colours all correlate with the words, etc. So that it's fine. And just check, I understand that the council has seen that document.
Correct, ma'am, thank you.
I've also got a copy of the council's SPD on, I haven't got the title in front of us, it's that one, yeah. Right. That's something that I think it should have come in early on in the appeal. It was clearly referenced in your appeal statement, and is that available on the website?
It is, ma'am, yeah.
It is, right. So has the appellant seen that document?
Yes, it was referred to in the statement of common ground as well.
Yeah. So I'm confident there that... I've also got the council's comment on the recent Hillside judgment, and that's dated the 17th of November 2022. Now, I just want to check, appellant, have you seen... I call you appellant. Just it's easier when there's three of you, if you don't mind. I just want to check that you've seen that.
Yes.
Okay. Now, normally you would have an opportunity to perhaps I might, because you've commented, you might want to if there's any further comment, but that's something. I think we'll be getting into that territory anyway through the housing land supply discussion. So are you happy to cover it off?
Absolutely, but maybe I'm skipping ahead. I'm assuming you've also received the response that we made to the council's Hillside note.
Yes, I have. Yes, that's on my list as well. There's quite a lot going on yesterday, and honest with us, I was travelling small screen. Yes, so yes, I do have that as well. So you're happy, yeah? Right, okay. Nothing else in terms of, other than the statement of common ground for housing and land supply. There's nothing else that's lurking around that I haven't seen that's happened in the last couple of days.
I think the only matter, ma'am, may have been an update on the marketing of the site, which the appellant submitted on
yes,
Friday.
I've seen that as well. I have actually seen that as well. I haven't accepted that to because I wanted to find out from the council whether or not you were happy for that to be accepted to the inquiry.
We haven't had a chance to review it, ma'am, in any detail.
Okay, so that's something that if you could do that, if we at some point when we adjourn, if you can have a look at that. Again, I think in the, I mean, not to preempt you, but in the spirit of what we've had in terms of information being updated because of the passage of time, it may well be you maybe want to think about it in the spirit of what else has been accepted, and how helpful it may be to the inquiry, to the hearing as well. So I'll just ask this now. Is there any other evidence to be submitted that I'm not aware of?
There is a silk compliance. You haven't. I'm sorry, I beg your pardon. I keep forgetting to do it. I think I remember when we go into the other room, because the setting makes a difference. The silk compliance statement, I think, has been provided to us by the council.
Thank you. Yes, that's correct, ma'am. Yeah.
I now just want to move on to the plans, and they're the ones that are listed in I understand they're the ones that are listed in the statement of common ground at 4.2, and also they are the ones that are listed in the proposed condition number 5 as well. So I just want to check that there's no change to those.
No.
Okay, thank you. So the application's made an outline and all the matters except access are reserved, as I said earlier on. Now, it probably might just be a very simple. Can somebody please explain to me the difference between Plan 01A and Plan 12A, other than the scale? Because I am, and this is the indicative. It's a plan that shows an indicative layout and the access arrangements, but one's a scale 1 to 1250 and one's a scale 1 to 500, and I can't for the life of me see any difference between the two other than the scale, so I would love to be enlightened as to what there is a difference.
Ma'am, I wasn't involved in the application being submitted itself, and I had a similar query myself when I was reviewing the papers, but I came to the same view. It was simply a matter of scale.
I wouldn't depart from that at all, ma'am.
So my next question would be, I mean, it's something that just, does that condition need to refer to both?
I think given that they're identical, it is simply a scale differentiation between the two. I don't think there's a need to refer to both of them.
Right, okay. So if we can hold that thought, and when we get to the conditions, if we can who can sort that out. Obviously, the larger of the two is more helpful in terms of the access details, isn't it? More legible. Now, another thing just with it, I just want to clarify. Obviously, I'm considering access, and access can be access as in the road frontage, the point of entry, or it can be the extend to the access, the internal access road. Now, the indicative plan, the plan that I have, the illustrative plot layout plan, that shows it shows clearly the entry from the main road, and it also shows a length of internal road with footpath on either side that goes to like a hammerhead, and then you've got a lot of shared drives potentially coming off that. I want to know to what extent of the access I'm determining, because I don't know.
Yes, Mum. If you look to paragraph 4.2 of the Statement of Common Ground, what that's trying to clarify there is that the drawings would only be approved insofar as they relate to the access to the site. So I would be taking that, if we had plan 01A, as literally being the junction into the site, and we can see some figures given the dimensions for the road width and the pavements. It's effectively up to that point. Otherwise, you start to overlap with what would be layout in a reserved matter,
Exactly.
which I don't think either party is looking to try and get approval for now.
Right, okay, so it's... That then leads me on to... I mean, I'm going to pick it up now while it's in our minds, is to... I've planted the seed, how that is going to work if I was minded to allow the appeal and that condition was there, how that work, whether something needs to be shown on the plan that like a coloured line or a shaded area that actually, so it's absolutely crystal clear the extent to the
yes,
to what
ma'am.
is dealt with.
Also on condition C5, that again we'll discuss later on, there's the reference in that condition to it being similar to the way that I've just described.
Yeah.
Where I've had this before, sometimes inspectors have added the words, rather than trying to substitute a plan in, perhaps we could scale that off and say it's the first X metres into the site, as shown on that plan.
Right,
I think that would address it.
So if we can, I'll leave that with you both, and you can work your magic to come up with some sort of further clarity. And just for anybody participating who's not used to planning appeals, we're talking about conditions. That isn't to prejudge the outcome of this appeal. It's just that I have to be able to go away with a list of conditions, so I've got them for the eventuality if I were to allow the appeal. And obviously, if I was to dismiss the appeal, then they obviously wouldn't be relevant. But they don't. The existence of the schedule and the agreement between the council doesn't actually undermine anybody's case or predetermine my consideration. Is there anything else that anyone wants to make me aware of in regard to the plans before we move on? Thank you. So just moving to the conditions and planning obligations, we're going to need to have a discussion on what conditions might be appropriate, as well as the appropriateness of the proposed planning obligations and the mechanism which has been put forward by the appellant to secure them. And that's standard procedure. And we've already established that list is the list that I have is the current agreed list, so that's good. Now, turning to costs now, I've not received any applications for costs from any of the main parties, and I'm not inviting any such applications. However, if there are going to be any, then they need to be made before I close the hearing, and preferably made in writing. Otherwise, it takes a little bit longer because I'll have to write everything down. There is a point later on the agenda which affords the opportunity for this to be heard just before we close. Now, in addition, I do have the power to initiate an award of costs against any party if I consider that there's been any unreasonable behaviour. And this does include new or late evidence where this isn't helpful to the fairness or the efficient running of the hearing. But I'm sure you're all aware of that. But I just want to remind everybody. If I were to do this, it would follow the written process with the relevant party after the hearing closes. I'm just going to move on to the site visit arrangements. I've got a general awareness of the site surroundings from the submissions that have been made. Unfortunately, due to my travel arrangements yesterday and the weather and the time of year, it was not practical to be having a provisional look at the site. That's not necessarily a bad thing in my mind, because it means I haven't got any. I'm listening to the evidence, and I haven't got any preconceptions. I find so it's not. It isn't a problem. However, I'm intending to make my visit tomorrow morning, weather dependent. I do have the full day available. There doesn't appear to be any reason why I can't do that unaccompanied, and I just wanted to check with you both as to how you felt about that. So if Councillor first.
The only question in my mind, ma'am, is whether or not any third party, particularly an adjacent occupier, would like you to view the site from their properties, in which case it would need to be accompanied. But that will come out during discussion.
As a point of principle, we've got no objection to an unaccompanied site visit. We can either make arrangements for the gate to be opened, or you can just walk to the public right-of-way and walk through the woodland into the broader area.
Okay. And then is there anyone here that was hoping that I was going to make a visit to their property? Okay, thank you. So
Okay, in that case, ma'am, the council would have no objection to an unaccompanied site visit.
Okay, thank you. So it's assuming we get all the way through the agenda today, it would be my intention to close the hearing before I made the visit, and that's normal practice for hearings. So it is important that before we close, whenever that is, that everybody's made the comments that they want to make, because I won't be able to take anything unless there was some massive change in national policy or something like that we had to sort of reopen on. So I've just got some points of clarification that are going to help me, and just things that have arisen through the course of me looking at the evidence. So they don't the questions that I've got, but don't sort of give any indication as to what my thoughts are at the moment. It's just it's part of my being confident that I fully understand everything that's been put in front of me. So the undisputed matters are set out in the Statement of Common Ground, if I call it the Planning Statement of Common Ground, which has been signed by both main parties. And I think we've already established there's no change to that. Okay, so we'll be taking it as read by and large. But obviously, if you want to draw my attention to anything as we discuss through. Now, I understand that the development policies which are relevant to the appeal are contained within the Peterborough local plan, and they are listed in 7.7 of the Statement of Common Ground as well. And I've got copies of, I think there's been a bit of to and fro and to make sure that I've got the copies and the support and text that went with it. I've got all of that now, so that's fine. So I just want to check first of all with the council, has there been any change to the development plan status in the interim?
Nope.
Okay. Is there anything that anybody wants to say about the development plan? And there's not been any neighbourhood plans in the area neither? No, okay. So just sort of moving back onto the Statement of Common Ground for the housing land supply really. So the timing of the submission of the council's revised evidence, as I said earlier, it gave the appellant quite a short window of time before the hearing to respond by way of their addendum. And that's really had a knock-on effect as well, with the ability for the council to respond to that. And then, without playing ping pong, it's always good if I know that everybody's had had sight and had an opportunity to comment, and for the appellant to have the final word on it. And then obviously we've got the Hillside judgment note that was circulated yesterday by appellant again. The timescales for that have just they've been dictated. Just it is a linear chain of events that has had to happen, and it's just so happens that it's gone right up to the wire really. Now I want to establish whether you're both happy to continue and have the discussion on housing and land supply today to see where we get to, or whether you feel that you need some time to consider the respective positions. And I think this is all tied up where we are with the housing land supply statement of common ground as well. Because what I need is I'm quite happy to, if I've got, I understand the arguments that are being put forward from a methodology perspective, and it'll be for me to decide which way I go, and I think I've certainly got from the appellant, and unless there's anything, the unknown is whether or not there's anything that whether you would have said anything different to what you had, and that's a bit that I'm conscious of. So I'm happy to go away with them, because the positions are the positions, and unless you're going to tell me otherwise, they haven't moved on. But it's the sites as well. It's when you're starting to think about the sites and how everything has a knock-on effect. So it's really whether or not you want to deal with housing lands, try and deal with housing land supply today, or whether you feel that it needs to be dealt with it another time. I'm just all I want is fair. It's just fair. It's fairness, and it's such an important issue. It's such an important issue for the case. I was
just saying I hadn't had time to look through the amended statement of common ground, and that does bring in some of the disputed sites are similar to last time the same. So I have had a bit of chance to go through, but I kind of thought that could form part of the debate, those sites.
Yeah. So
agreed. I'm happy with. I've got enough. Been able to yesterday afternoon quickly find enough information to sort of be able to talk through that.
Everybody, please.
Is it? They've set the forum. Yeah.
Sorry.
Well, it's normally 10 o'clock they do the test. It's 11 o'clock.
11 o'clock. Sorry.
That's what I thought. wondered if it was the building work had set something off.
Well,
Do you want
normally
to-
the
I'll
fire
just
alarm
double
keeps
check.
going if it's
Yeah.
a fire.
I'll just double check.
I think we've...
Some of the people are fleeing the building from the problem.
Because it's a different sound alarm. I do on fire alarm, I do like bomb tests as well.
Oh, right,
That's
okay.
all sounds like that, so I think it's just
Yeah, because I did check this morning and it said there wasn't anything to happen, so... Thank you. Are we okay? Thank you. That you're able to move things on and give me the necessary clarifications through the course of the areas of dispute, but but it depends upon whether I've got a house and land supply statement of common ground in front of me.
Probably by the end of the hearing sessions, if we debate some of these sites and the information that new information we've got from the monitoring reports and things, we could probably agree this, and there'll be sites that we still agree to disagree on. There's still disagreement on those sites, but
yeah, I think all I want to be able to go away is with a clear understanding of where the areas of agreement and disagreement are.
Can I perhaps suggest, if Gemma has any additional evidence we haven't yet had sight of, that perhaps we step outside the room and get our heads together and see if we can narrow down any areas of dispute.
Yeah,
and perhaps then produce an updated statement.
I think most of the information from the sites is information that was already mentioned in the 5-year land supply in the comments box. And there's perhaps just some information about more up-to-date completions data and things like that. So it's just factual information that I haven't written up because I haven't had time. It's just my notes. But happy to share that with you. Well, I thought we could debate it and share it afterwards. I don't mind.
Am I going to have a statement of common ground by the end of today, do you think? Or
I'd hope that if we debate some of these sites and things like that, we could come up with something at the end of the day. I'd hope so.
Yeah, I'm happy to go with that. I mean, if we can narrow areas of dispute, obviously, before we actually debate, then that would be obviously ideal.
Yeah.
But yes, I'll go with whatever your recommendations.
Well, I think what we'll do is we'll move the house and land supply to the end. We'll get through everything else to see where we are, and then we'll deal with them, because what I don't want to happen is to get stuck on house and land supply, and then we've got like about 10 other items on the agenda that we don't get through, and then take it from there, because it may well I'm just thinking aloud, it may well be to whether or not you can get something because you're here. You can't be doing two things at once. Sort of finalising a document for me. So we might have to give a window to deal with some of it in writing.
Absolutely. I mean, the statement of common ground as is just shows the state of progress up to a certain point in time. Mm-hmm. And what it does, well, hopefully what it does, is it just sets out the council's latest AMR position and the appellant's position. So it may be that that is actually as far as we get
Yeah.
in terms of discussion, so it might still be a relevant
Yeah,
and
yeah,
valid
that's it. And
document,
it's because the dispute is a dispute at the end of the day. I think I just want to have it clear in one in one and go away with an understanding of it.
And
So
I hadn't been able to, because I was on leave, I've only was able to read this on the train on my phone, so I couldn't really agree anything till I'd read it properly. That's what the delay is about, just it coming in just as I was going on leave.
yeah, and there's like the lunch time. So if we will, sorry, if you probably haven't worked, you'd be used to having working lunches for this type of thing. But there is like a opportunity at lunchtime. But we'll move housing and land supply down the agenda and deal with it so it doesn't derail anything, everything else. And then we can give it the time. Okay. I just want to, in terms of the term, because the description and development refers to prestige self-build sites. So, but the reason for refusal, the council's fifth reason for refusal refers to serviced plots. And I think there's, in the evidence somewhere, there's something around serviced plots. And I'm just wanting some clarity on, has that just sort of cropped? Is it part of the proposal, or has it cropped in when it shouldn't have?
I think it was my understanding that the council's approach was simply how do we secure the type of development through conditions or Section 106. That has since been overtaken by the unilateral undertaking, which appears to, well, is an agreed position now that would address that reason for refusal. So the units would be qualifying as self-build units. As for the prestige element, we've got a separate condition, which was requiring a statement to be submitted so that there's a demonstration that it would meet an expectation of what prestige homes should be.
But is the term serviced plots, is that relevant to this? Is it relevant to my consideration at all?
I don't think it is, ma'am, no. The council is satisfied through the unilateral undertaking that these would be self-build properties, and that was the concern, really, that if that policy in the local plan was to be paid in aid, then it need to be demonstrably satisfied.
Okay, so I think what I'm getting at is because you've got self-build, but then you can have self-build schemes where the serviced plots are provided, and then there's somewhere they're not serviced, and it's like an additional element, and
I didn't see that as being a particular issue, but it would be something where a developer could deliver, for example, the access road up to the point of a unit that would then say, well, that then becomes a service plot. Then the plot the unit that's built on that plot must comply with the terms of the 106.
So I suppose what I'm thinking of, is it something that either of you are relying on as being a benefit?
I don't think so. I think it's simply a matter of it's how these types of units would be delivered and secured. The self-build element, we're clearly saying, is a benefit of the type, but not in terms of service plots.
Okay.
Yes, I would agree with that.
Okay, thanks. That's helpful. And then, in terms of the term prestige home, is there a definition anywhere that anybody can direct me to that is a tangible? It's not just, I think the local plan talks about top end, high quality or something like that, which still isn't, it's.
I think this is where I'd be going to, is the supporting text in the local plan around 6.4.7. It actually says itself that there isn't a definition as such, but it then goes to try and explain what they may be. It talks about them being higher end units, possibly in the top 10% price bracket. It talks of them typically being larger, say 5+ bedrooms. And it also talks about them being individually designed. And then it goes into matters of high specification. So that's where we felt that to give the council the comfort, the condition requiring a statement saying this is how it's going to be delivered, they could look at that and say, is it meeting their expectation of what they think prestige housing is? Because they've identified the problem in the local plan and we want to address that.
Okay. And is that something that the council's had to deal with before?
It is. Jem, did you want to?
That's why the local plan talks about prestige homes. That was because that was an ambition of the council to have more high quality homes, and that sort of came in before the Self Build Homes and Custom Builds Act. But it's just a way of trying to acquire bigger properties that aren't necessarily self-build, but just bigger properties for meeting that part of the market and the high demand. So larger properties in the higher council tax band.
Okay. Thank you. I just want to, because obviously through the discussion, when we're talking about attributing weight to harm and benefits, there's all different types of wording that people use, and I just want to just so that we're all on the same page with when we're talking about the different sort of levels of weight. I've just picked up some so. Without quoting who has said what, we've got terms such as substantial, very significant, significant, and some weight. So I suppose, are substantial and very significant, are they between the parties, are they equivalent, or are they? Because I'd just like to try and stick to some consistent terms so we don't get into a knot.
I thought that I might have a footnote because I noticed that some appeal inspectors had started to put their traffic lights on the bottom to say what they would be. I would have substantial at my high end. I would say that's the same as very significant if somebody else wrote that elsewhere. Significant would then be underneath substantial. I would then have moderate. And then I'd have limited. So that would be my traffic lights.
Okay. And would considerable and substantial be, are they all at the high end of?
I'm not sure who's said considerable or,
I
think what we're talking about, where I say substantial, that's at the highest end.
Right, okay.
And then significant is reflecting what's in the MPPF on certain matters.
And
the only addition that I would probably make to that would be at the very bottom end of the spectrum, where there is a material consideration that needs to be noted, but it really doesn't have much effect on the planning balance. And I would call that maybe very limited weight.
And very limited, okay. So for the purpose of this appeal, that's what I'll be referring to: substantial, significant, moderate, limited, very limited. So it's like a 5-coloured traffic light. If such thing exists, just so everybody's in the same, we're all in the same page there.
Can I just get a small clarification on that point, because I know that the council do refer to the word some in places.
Yeah.
But they also refer to limited. Are they the same, or?
Did you?
Yes, I think that's probably fair. So some weight will be limited weight in the councils.
Some very limited or limited?
Limited.
Limited, hang on. Right, okay, I'll just... And then the very limited is... Right, okay. So I just understand just a little bit of context, really. So there was a significant amount of time passed between the application being submitted and the appeal being lodged. Was there any particular reason for that? Were the parties hopeful of a negotiation that would be favourable? Was there a particular sticking point, or is it just...
I picked up the application at the point where the appellant, or applicant as they were seeking to appeal. There was a few points where we were seeking clarification from the council. Was there anything further, and did they have any further views? There were certainly the matters to do with the SSI, where the Green Willows report was seeking to find a avoidance/mitigation strategy. So that, I think, certainly left a large part of the time. But then towards the end, it was really a matter of asking the council, well, have they reached a view yet on the principle? And it was at that point that we put the legal opinion in to do with interpretation of policy. They went away, looked at it and said, no, we're still going to object in principle. And then the decision was made to appeal non-determination.
Okay. Is there anything that the council wants to add?
I'm just looking at the chronology on our files. The application was submitted in spring 2017. We issued a position statement to the then applicants in February 2019, and I'm not sure why there was that delay, ma'am. Then it appears that it took about 10 months after that to resolve ecological and drainage concerns, and we had nothing further until the appeal was submitted.
Okay. So it was really, in essence, about trying to narrow the gap, working to try and narrow the areas that were of concern.
I think on the matter of the technical points, yes. Ms. Croucher just said nothing else happened after the ecology. There was a time there where there was a new officer. I was new to the application. We were trying to resolve this issue of policy interpretation. So that did take a bit of time to get a response. Eventually the council said, we don't agree with you, and we just decided, well, we...
Yeah, okay, that's fine. Just so it's useful to, just that bit of background for me, useful to understand how that was happening, what was happening there. Now, the Wansford Conservation Area is 60 metres or so to the southeast of the site, and there's a Grade 1 listed church, Church of St Mary's, about 280 or so metres to the east. And the Statement of Common Ground at paragraph 8.37 states that the council doesn't raise any objections with regard to the impact of development on the settings of those designated heritage assets. Now, obviously, as a decision maker, I've got particular duties in relation to heritage. I suppose, and I've got to make sure that I've got to check that whether or not they are engaged and satisfy myself. I'm just reading this for the council. Is it a case that you've assessed that there's no relationship with the designated heritage assets themselves or their setting, and therefore the matter's not relevant? Or have you assessed that there's a relationship but there would be no impact to the heritage significance, so like a neutral effect? Because the two things are they're very different, and I'm not clear.
To assess, ma'am, it is the council's assessment that the site is sufficiently divorced, both physically and in terms of the visual relationship, from those heritage assets as to have no effect.
So that it's a case of not being relevant yet. Thank you for that. That closes that one down. Now we'll be moving on to the main, what our class as the main items, i.e. the item 3 to 9, linked through to the main issues. And I've got a list of questions that I'd like to focus on and to explore particular aspects that either I'm wanting to check, to probe, or to further my own understanding, just so I'm absolutely crystal clear when I sit down to write my decision. So just because we don't cover a particular point or issue, that doesn't mean that I've made my mind up on them or that they're unimportant, or is something that my decision will turn on. It's because we've got a particular amount of time, and there's got to be a particular focus, and that's why when I keep saying things are taken as read, That is that's what that means. And I will be addressing any what I call losing party arguments. So if the appeal doesn't go, the result isn't the result that you hoped for, your arguments, you should be able to find those within my decision. So hopefully my questions will strike up a discussion, and that might lead to some supplementary questions. And as I said earlier, I'm happy for you to refer back to any particular sections of your evidence without sort of repeating them too much. If you feel that'll help me, just particular paragraph numbers or whatever, that would be really helpful. So I don't know whether we need to decide whether or not we're going to move rooms or whether we're going to continue on.
I think given that the noise has subsided slightly, I think we're probably okay to stay here, ma'am, but we will be led by you, ma'am.
Do you want to check the other room and just see what it's like?
At the moment, if everyone else in the room is happy, I'm happy to continue on unless it gets in. But I just want everybody else to be as happy as we can be. Yeah. We'll continue. We'll continue on as we are at the moment, because as you say, I can't decide whether it's subsided or whether I've just got used to it now. So. But, do you want a short break, or should we go into item 3 and because I'm happy I can plough on for hours, but I'm just conscious that other people maybe don't necessarily always have the same stamina. But
Can we take a short break?
Yes,
Speak some discussions as well. I'd like to take myself on as well.
Yeah. So if we say, is 10 minutes enough?
For me it is, thank you.
Yeah, so we'll come back at so we'll adjourn at the moment and we'll come back at 11:30. So thank you very much. Okay, it's just gone 11:30 and this hearing is resumed. Thank you everybody for coming back. Just before we move on to item 3, I just want to give main parties an opportunity. Is there anything that you want to say by way of like a opening or introduction, or are you quite happy to continue on to the matters?
Well, so you're happy we've set out our case?
Yeah. Exactly. Yeah. I'm satisfied, but I always like just to give you the opportunity if you wish to. And as we've said, in terms of Mr. Stanage, it's probably more appropriate for you to contribute to the discussion rather than so that you're not just repeating what you've written on behalf of the council, the town council. Thank you. So I don't know whether you want to. Do you want to move up to the table, and because we're going to start on the. Yeah, that's fine. Yeah. I'll let you just move and. It may feel very formal for you. I suppose with your dealings with the parish council, you've got experience in public meetings, etc. So if you just think about it as one of your the public meetings that you hold with the parish council, it's not as it's still a formal proceeding, but not as official as a public inquiry where you're being cross-examined or anything like that. We try to make it a bit more a bit easier on participants from that perspective. So hopefully, so I think if you might want to, in terms of spatial strategy considerations, it might be useful for you to have a copy of the council's first reason for refusal, the draft reason for refusal. We'll if we refer it to, because that sort of really is in essence the nub of the issue in relation to the spatial strategy considerations as far as the council's concerned. And it might also be useful to have policies LP2, LP3, LP8 and LP9 to hand as well when we're running through this part of the agenda. So whilst the appellant has recognised conflict with policies LP2 and LP3 of the local plan, my reading of the evidence is that what you're saying is that the appeal scheme gains support from policy LP8 in terms of meeting housing needs, as it will provide 14 prestige self-build plots to meet demand, and also LP9, which is the custom and self-build and prestige policy. And you believe that the appeal scheme isn't in conflict with the local plan when read as a whole. That's my understanding of the of that aspect, part of the case. I've got some particular questions, so I have got the clarity that I need to make sure that I'm giving the correct interpretation and application to those policies, and because that is one of the key points of dispute. Before we sort of get into those policies LP2 and LP3 to start with, I've just got a couple of queries about the accessibility credentials of the site, and it just seems sort of most pertinent part of the agenda to deal with these. So reading the evidence, there is some. This has led me to raise the question of whether or not Wansford should be taken as a separate settlement to Wansford cum Simpson, which I believe is because it's on the edge of the local authority area, the settlement. So for the purposes of your settlement study, where you've assessed the accessibility to services and facilities, and that's informed like the settlement hierarchy. I think what the appellant is argued that you may not have taken all of the facilities into account, and I'm just wanting some clarification on that, because for all we've got, the council isn't, from a day-to-day perspective, the council isn't an island, and those facilities, if they exist in Wansford, cum Sibson, and they're X-distance, I just want to know whether you how it's been dealt with.
A settlement hierarchy was prepared to support the local plan and the settlement hierarchy policy and the position of villages. So if you'd like to see a copy of that study, that is available on the website if you've got one. And we did, as part of that work, you do take account of what's in the adjoining boundary and as part of the assessment of overall facilities. This issue did come up as part of the local plan examination. So I can check back if you want to see if there's anything that came up at there, unless you've already done that and got the information.
Okay, so maybe, yes,
What might assist is if you've got Appendix 3 to my hearing statement, and it was, I think, the topic paper that you were talking about, and it's the Peterborough Settlement Hierarchy Study.
Yeah.
And within page 6 of that document, what we have there is a list of all the facilities which do or don't exist in the various settlements. And it's just striking that there's crosses, meaning they don't exist, against a number of facilities that we know are just the other side of the river. I read the settlement as a single settlement, and I think day to day people will use it that way. But certainly we have crosses against food shop, post office, doctors, dentist, community hall, pub, non-food shop, and we know that they all exist, and they would be in walking distance of the site, and therefore I think the plan is the plan. I can't dispute that, but as a matter of fact, accessibility facilities is greater than the settlement position Wansford's been given.
Would you like to just respond to that? And
Yes, I mean, this did come up as part of the local plan examination. So I was just going to check through the inspector's report, but one of the sort of cases made was that although the village is seen as one, it's split by the river and the bridge over the river, and although you can access between the different parts and it is one village, it's not an ideal road and easy to walk between the two settlements, as it's not just a case of just crossing the boundary, it's over the river. I'll just see if I can find anything, because this was discussed at the examination. So,
I could just help on. I mean, I had a look at it, and I can't see any discussion of this issue in the examiner's report. But it may be that I missed it. So.
Okay, Mr. Stanage, from your perspective, how does everything how does it work in terms? Because obviously I'll do a site visit, and I'll be there for the morning, and I'll have a look around, and I will look at the access to services, facilities, etc. But is it from a local? How does it work from a?
Well, I can tell you how that works better. I can tell you how this works. That's better. It seems like it's not plugged in.
Oh.
Okay.
Okay.
Right. Well, I'm only doing this for the benefit of the YouTube, because I'm sure you can hear me. Now, Wansford is a village separated by into two parishes. I'm not calling them opponents, I'm going to call them the owners of the land. Because I'm not one of you professional people. The owners are quite right that Wansford village has shops and hotels and post office and whatever, and a doctor's surgery and a dentist and all this type of thing that are in two other counties. The doctor's surgery is in Northamptonshire, and the other facilities are in Huntingdonshire.
Yeah.
But they are accessible to the whole village. Okay. I would probably argue in practice that they're actually walked to. Most of them are driven to. When you look at the side of the car parks and the areas that are occupied by vehicles at any given time, the doctor's surgery certainly is a large car park that's mostly full. So I'd argue that probably people don't walk to them, but the facilities are there. But we are two parishes, and 2 counties, basically.
Okay.
So I can say no more than that.
Okay. Thank you very much. That's just helpful to get just a local perspective on that. Thank you very much. So can you just clarify to me where the nearest primary and secondary schools are? And do they, and just with the passage of time, or is the council still satisfied that they've got capacity? Because there's no planning obligation being sought for educational capacity. So just wanting to.
My comment was going to be that the settlement hierarchy study and work was done to review that, but it was based on what had been in previous plans, and Wansford has been classified as the equivalent of a small village in all the earlier plans as well, so it's not something that's changed. It's been a consistent approach going back to the 1996 local plan of its position in the hierarchy. I'm not sure what the latest is with school capacity in Wansford, in the nearest school, so I can't comment on that, but I can find out if you wanted information.
Okay, but it's not something that the council was not seeking and.
Still.
Yeah, so just to clarify, ma'am, the Peterborough City Council is a SIL charging authority, and the education provision is a SIL matter.
Okay.
So it would fall outside 106 in this instance.
Right, okay.
Anyway.
Right, that's fine. And just out of interest, where are the schools in terms, Mr. Stanage? Yeah.
The closest junior school is Wittering, and I would say the secondary schools are Peterborough, Glinton, Peakirk, that area as well. But I would stress that all students, whatever age, have to travel to those locations either by bus or car.
Okay, thank you. Is there anything that you want to?
Yeah, there was just a couple of points, just in terms of what was mentioned a moment ago about distances and so on. I've got those set out in paragraph 7.40 of my hearing statement, which talks about how far they are.
Yeah.
Yes, people might choose to use their cars, but in planning terms, there is the opportunity for people to walk and cycle. They're in those reasonable distances.
Okay.
Again, on the matter of the schools, I'd also had attention brought to Castor, and that being within a 5-minute bus journey as well.
Okay.
So there's an opportunity to use public transport even for the schools.
Right, okay, thank you.
Could I just come in here? We don't have a very good bus service in Wansford. Now, I think the children are provided for, but any other adults would have a difficulty in getting from to the outlying villages, Castor or Wittering or whatever, unless it was by car.
Okay. Thank you. That just gives me more of an understanding and in terms of how things sit. And so in locational terms, if I was to find that the accessibility credentials of the particular site are appropriate, is it merely a measure of sustainability that's a local and national expectation of all development, and therefore of neutral consequence in terms of, or is it something that was something that I read in terms of Pellant that I felt as if it was being advanced as a benefit?
There's a slightly unusual situation with this type of proposal. Had it just been ordinary housing, I could imagine me agreeing to the proposition that you just put forward. But the situation that we have here, as evidenced in the local plan, is that the type of people that these homes are aimed at are already in commuting from much further distances. In fact, they're not, I think it was at half of senior professionals and executives were coming from outside Peterborough itself in terms of its the city. So there's an opportunity there to actually reduce commuting distances. It sounds counterintuitive because you're talking about a village, but there is an opportunity to reduce that distance to bring those people closer to Peterborough.
Okay, and is there anything that, Councillor, you want to
Only
respond?
to point out the obvious that that doesn't mean that an unsustainable location is made acceptable in principle, simply because of the nature of housing and the fact that its potential future residents may well be commuting anyway.
Okay. That's helpful. That just, I've picked up what you. Is there anything that you want? Anything else that you want to get to? Because I think what I've done. I've read what you've said, and I've understood it in the way that you intended it. I think is what.
I think so. But I think it still goes back to the point that there is no embargo on the villages, the medium villages, the smaller villages. There is housing that was even allocated by the council in those locations, and we've just had the discussion about facilities. So I wouldn't call it an unsustainable location.
Okay. Thank you. So now I'd just like to move to policies LP2 and LP3. I'm just going to get my copies of those. So I've got them. Now I'm going to be reading off this so that I get it. So I'm correcting what I say, what I mean to say. So just excuse me for. If you feel it, I'm reading off my sheet. So policy LP2, that defines the village envelope. I think you call it a village envelope, don't you, rather than settlement. I might slip into settlement boundary because but as long as you know that's the same thing. And that defines the village envelope, and it also shows which areas constitute countryside for the purposes of so that's my understanding. And policy LP3 tells us that for Wansford, unplanned residential development on unallocated sites will be limited to infill or redevelopment of sites of a scale appropriate to the village. And then you've got policy exception that gives there are exceptional reasons of exceptions to why you would allow other housing outside of the village envelope. So that's what we're dealing with. So from my reading of the evidence, the appellant is, and particularly Mr. Hutchinson's evidence, you acknowledge that the site is, because it's outside the village envelope, that it conflicts with those. There's a conflict with the local plan in relation to the village and in relation to the village. Yeah. If you look at that in isolation, and that's your point. So that's the sort of starting point. So just thinking about the reasons why policy LP2 and LP3 came about, and what their objectives and what they're trying to do. What particular harm, if any, would the appeal proposal impose, bearing in mind those objections? So the council's saying it. I think there's a consensus that it does. There is a conflict with that policy in isolation, but it's like what's the harm? That's what I'm wanting to get to, because that's not not in relation to other policies, but in relation to that, what is the harm? Because that's the
LP2,
space track.
LP3
What is the
harm?
harm? That's what
Yes.
I'm wanting to get to. So if I begin with the council, then is that all right? And then you can, yeah.
The fundamental spatial strategy that the council has adopted is to direct growth either to the urban area or to one of its urban extensions. And in order to prevent uncontrolled growth outside those locations in the countryside, the village envelopes have been identified on the various local plan maps. And that fundamentally is the purpose of the village envelope. It's to direct development to the locations that the council finds most appropriate.
So, what is the harm of something, setting aside character and appearance, I think, what is the harm that would arise to the spatial strategy
Okay,
if something fell outside?
Departed. It would allow uncontrolled sprawl of both the main urban area and also of the many villages within the city's boundaries. And it would undermine the council's attempts to regenerate the central areas within the city. Absolutely, it's incremental additional growth, and the more dwellings that were provided outside the village envelopes, the less demand there would be for regeneration of land within the existing urban area.
Yes, no problem. I think in the first instance it's just a literal harm of conflict with a policy, but like you say, what's the tangible planning harm? I don't think we've got to view it in the context of the actual proposal. It's not just a matter of should we set these policies aside for all types of development. Allowing 14 units of self-build prestige housing isn't going to lead to a fundamental distortion of the spatial strategy. I think the council say that this is one of the fastest growing cities and therefore development is happening in those other locations and we can see it all around us. This particular type of development, even the SHMA is saying the demand is being identified in the village type locations because that's where people wish to live. If those opportunities aren't provided in those locations and you're told, well, you must go to the city, these people will just continue to commute and therefore we continue to have the planning harms that the plan's trying to address. And I think just as a sort of general point, the NPPF doesn't preclude development on greenfield sites, and we were all familiar with other local plans that might take a slightly different approach. This actually is one which is very restrictive to any development outside unless you're in those exceptions. So I'd say the harm is very limited and has to be balanced with the benefits.
Madam, can I just make two additional points? Yeah. If I just distinguish the harm that would arise or might arise from this proposal versus what is the harm that the policy is aimed at. The policy is aimed at sustainable harms connected with sustainability that we've been discussing. That's what we're told in paragraph 5.8, that it's to enable more sustainable patterns of development. So it goes back. Then, what is the harm in that? What is there any harm of that type in the context of this proposal? For the reasons Mr. Hutchinson has given, no, because for this type of development, the position, as the Shmar recognises, is people commuting from out, and there is no competition of demand. We're not displacing demand that would otherwise be met in the city itself. So that's why, just echoing what Mr. Hutchinson says, that one has to consider the nature of the proposal, the facts on the ground. The second point, just in support of what Mr. Hutchinson just said in terms of the government's position on it, I think, Madam, in Mr. Hutchinson's appendices, you have a copy of the settlement hierarchy study, which references at 3.5, paragraph 3.5, the PPG advice that blanket policies restricting housing development and preventing other settlements, in some settlements, preventing others from being expanding should be avoided unless thoroughly justified. And what we're saying is there's a reason why for an expansion for this type of development in this location. Thank you.
Okay. Wansford is classified as a small village. That's the first thing. And residents are very protective, well, Wansford Parish Council and residents, because we represent residents, are very protective of village envelope, as we are the conservation area. Our fear is that if this development goes ahead, in other words, you make a decision on that, we will open quite a vast area surrounding the village to speculation, which is open countryside. The City Council will have great difficulty once one opportunity is taken of preventing the others. That is our concern within the village. It is a small village. There is limited infill, but the majority of houses in our village have very large areas of land within their curtilage. We are seeing now some of those properties being developed in addition to the main house. In one instance, there's 2 houses being built, large houses, I would call them prestige houses, in the curtilage of that property. So it is happening within the Wansford village to supply prestige houses. And I would imagine going forward that will continue. Thank you.
I think I'd just very briefly say that in terms of precedent, this is a particular type of application, a particular proposal, and I can't comment on what would happen with other applications, but they would have to be considered on their merits.
actual words of the policy?
Yeah, I had some difficulty in looking at this the first time I did. I think it's quite clear the supporting text and the approach of the council is that there is a need for more prestige homes. The wording of the policy, when you read the first part, though, does appear to be referring to the loss of existing and seeking to protect their loss from their loss. But we would see elsewhere, we've also got, for example, some of the allocations where there's reference to prestige housing there as well. So I think on any fair reading of the plan as a whole, the council is trying to encourage prestige houses, whether that's as proposed or not losing what they have. But I agree with you, the first part isn't necessarily saying...
Okay. That's fine, I just wanted to check that, and do you agree with...
I would adopt exactly the interpretation that you have adopted yourself, ma'am, yeah.
So, then moving on to the final paragraph. What I'm wanting to, because I'm looking at the wording of the policy, and I get the arguments about reading the plan as a whole and the supporting text, etc. But just in terms of the policy wording itself, does policy LP9, looking at that final, does it lend support to the prestige component of this particular appeal proposal? Given that it doesn't fall within the circumstances set out in paragraphs, the first set in paragraphs.
Sorry to skip around. I think what I'd be suggesting is read with LP8, which does talk about supporting a range of high quality homes, varying type, sizes, tenures, etc. That would encapsulate also prestige housing, reading the plan broadly. It also then talks about self-build. When we then get to back to your question on LP9, it's only referring specifically there to the self-build. I agree.
Yeah.
Thank you, ma'am. Yeah, I mean, the link is more crucial between that final paragraph of LP9 and the list of exceptions at LP2, which are appropriate in the countryside, and it is manifest that self-build and prestige homes do not form one of the list of acceptable exceptions at policy LP2, and to infer that they do would be wrong.
On that, it's not. I don't think it's. I mean, obviously, I provided my view in the written opinion, which is in there, and there's no change on that. But I don't. The argument certainly I wasn't put was that you imply a further exception into LP2 for these. It's that you read the plan. It's a plan as the whole point, and it's fair enough to say, well, it's not identified as specific exception, but as I say, there has to be meaning. I think Mr. Hutchins says that there has to be meaning given to a practical purpose and meaning given to more favourable treatment in LP9. And I think what Mr. Hutchinson says is consistent with what my view on this, which was that it's a more nuanced approach. It's appropriate opportunities for self-build, get more favourable treatment. It's not an automatic. You are an exception to LP2. It's a planning judgment considering the two policies in the round and in light of individual circumstances. It can be, is the way that I put it, I think, in my advice. And that isn't to interpret LP2 as having some unstated but implied further exception. It's to say those are the automatic exceptions, but when you're applying the plan as a whole, there is room for judgment that, insofar as there's tension, it should give way to the LP9 favourable treatment policy in an appropriate case.
get onto that
Okay.
term in a more.
Oh, sorry, I've jumped ahead.
No, it's fine. It's fine. It's inevitable. It's going to happen. I'm just trying to do it instead of trying to eat the elephant whole. I'm trying to digest it with bite-sized chunks, which will build up. Now, if we look at the final paragraph of policy LP9 again, I want to know what I'm trying to understand is it intended to be taken as two separate considerations, or are each of those sentences are they mutually dependent on one another? So you've got, just for the purposes of everybody who's in the room, it's the proposals for residential development will be considered more favourably if they provide appropriate opportunities for custom and self-build. And then it's, as set out in policy LP5, sites over 500 dwellings will be expected to provide service plots for custom build and self-build homes. So I suppose what I'm trying to establish is the view is, does that first sentence, which is considered more favourably sentence, does it relate directly to the sites of over 500, or are they two separate? They are two separate.
They are two separate, and it would have assisted, I think, in the interpretation if they'd have been split out,
yes,
which is the way that it was intended that they were interpreted.
So they are meant to be, right, okay. That's helpful.
I would agree, because one is actually setting a policy test, a requirement, an expectation that it's on the allocations, whereas the other aspect is this matter of an application might be considered more favourably if they choose to do self-build.
Yeah.
No.
It would, yeah. So it's got. It's not entirely clear. It's not entirely.
Perhaps if I can assist, ma'am, with a hypothetical example, that may assist. So we have a site which comes to us, which accords with the LP2 policy of directing growth to within the settlement envelopes, so the village envelope. I'm confusing my terms now, but that would cause less than substantial harm to the setting of a heritage asset. We would then say that the last paragraph of LP9 would be a material consideration which would help to offset that less than substantial harm, and that accordingly that scheme should be considered more favourably. And that's as simple, really, as I think the interpretation needs to be. It's a planning balance matter, absolutely.
I'll let you have
I'll probably defer to Mr. Hunter in a moment, but I think it's quite clear from his written opinion already that it needs to be meaning, it needs to be something which overtakes something which might otherwise be seen as being, let's say, an unacceptable form. I think it would be strange for the council to suggest that it would be allowing substandard developments, but because they're self-build, they seem to be okay, and therefore they'll be considered more favourably. So I don't agree with that proposition. Insofar as if it's just one in a settlement boundary, well, it would be considered favourably. It would have the presumption in favour under an ordinary policy anyway, so I don't agree with that. As for something like heritage, again, if we were to look at the weightings that the council have even afforded to self-build, I think they say modest and prestige some, so it's not even as if they're giving that much greater weight anyway over and above what you would be given to an ordinary market house. So again, it's quite difficult to, if it was consistent, if it was something that was capable of outweighing less than substantial harm to a heritage asset, which we all know is considerable weight and importance, then I'd expect much greater weightings to be put in there. So I'm not here to talk about what weights other people should put on things, but it doesn't sound logical when we look at the way that policy is drafted to take that interpretation, and therefore our wider interpretation is you may have appropriate opportunities that may be in the villages, particularly where the demand is greatest. They may be of an appropriate scale, and that might be something which could, on balance, taking into account whether it's designated land, whether there's other impacts. If there wasn't many of those, which is the case here, then it's something that's capable of outweighing the conflict with LP2 and LP3. So that's our general approach on that.
Yes,
So, what I would say is that the council's reading of the policy is unduly narrow, because effectively it's reading in words into the policy that aren't there. They are broad words, appropriate, more favourably. It doesn't say, but only if they comply, only if they are compliant with LP2. It's left as a matter of broad planning judgment in terms of the interpretation of the policy, and I'd say deliberately so, because it allows a proper judgment to be reached in light of all the circumstances. If it meant will be considered more favourably if there are opportunities for custom build and self build within village envelopes or within the defined areas, it doesn't have those additional words, and for the reasons that we've already explained, that might well be quite counterproductive, because the appropriate opportunities might have to be found outside those locations. So it's right that the policy left it open to be to individual planning judgment in the individual circumstances of the case.
Ma'am, sorry if I may, and I think it is important that we return to LP2, and I'd like to just read out the final sentence of LP2, and it is very clear. All other residential development outside of village envelopes and outside of Peterborough urban area boundary will, by definition, be contrary to the vision, objectives, development strategy and policies plural, of this local plan, and should be refused unless otherwise acceptably made within a neighbourhood plan. And I think that's very clear that LP2 has primacy over LP9, and that is where we must look in the very first instance as to whether development on this site is acceptable in principle.
I think we'd be repeating the points that we're saying, because to give it its proper meaning, it's got to be capable of outweighing other aspects, and it's a in the round, read as a whole type approach, and it's not a blanket pass for these types of developments, because they've got to be considered on the merits.
Sorry, could I just say, I'll just reference rather than going over the same points I made, but in the opinion, I referred to the case of Corbett. One of the policies that said will not be permitted. Court bill said can be outweighed by compliance with other policies in the plan. And also, the policy has to be read in light of its purposes. If you read it as strictly as the council do, what they are saying is, even when the rigid application of LP2 would lead to unsustainable patterns of growth, or overall unsustainable patterns, it trumps everything always. And that isn't a sensible or practical way to look at it. It's clearly given considerable importance. It may well prevail in many cases, but it's not an absolute. And LP9 is giving you a route defined that it shouldn't prevail in an individual case.
Yes, I'd agree with that, ma'am. Yeah. Well, I think, again, we need to just read that first paragraph in full, and it reads, development proposals for housing will be supported where they provide a range of high-quality homes of varying sizes, types and tenures. So I think that's a more a mixed and balanced communities type of policy, rather than one which lends specific support to prestige or self-built homes. I don't think so, thank you, ma'am. No.
I think in terms of the first part, clearly we've got the support for self-build. As I mentioned earlier, that could be taken also to include prestige, because it would add to the quality of homes, types and sizes. I don't take the same narrow approach as Mr. Croucher, that all schemes must deliver a range, because in a city centre location, you might have a scheme full of 1-bed, 2-bed flats and it has no 5-bed detached houses. It's a matter of our proposals that are coming into the authority collectively contributing to this range that's going to be provided. And I think the proposals would add to the diversity of types and sizes. The second paragraph refers to the matter of need. I won't repeat all the references, but you've seen in my evidence reference to the SHMA. We're also told in the PPG that we need to look to secondary sources as well. The SHMA tells us that these needs are not being properly represented in registers. The needs are likely to be greater. And we've come forward with evidence from Woodford and Co., which is site-specific, which identifies a very high demand for this particular site. It would represent another source of local evidence. And as far as I can see, that evidence thus far has been uncontested. About the two documents, first of all, the document was in with the original submission identifying the demand. That was uncontested. We've now updated it purely in anticipation that you might have asked the question, well, are people still interested a year on? Yes, they are, and that's all it seeks to update.
So because you've got
Yeah, going back to where I'd started, I think it's that matter of layering. It's at national level, PPG, the local level, the SHMA, the local plan, again at the local level. And what we've done, like you've just said, is testing it on a particular proposal, and that's also identifying demand.
So is that site specific? Is that people filling up in response to the...
Yes.
Yeah, I mean, ultimately, if you ask the question to anybody, would you like to build a home on a nice greenfield site with a nice view? Of course, they're going to say yes, right? I mean, you know, I don't think that's compelling evidence.
Sorry, I think this...
That was where I was trying to say that there's a distinction between something on the back of a piece of, back of an envelope compared to something that's maybe being collated by professional accredited person where you've got codes of conduct and things like that. So it depends on what the source. One of the reasons why these hearings happen, isn't it?
Yeah,
it's to test the evidence that I do have and the robustness of that.
I think just in response, this wasn't a question put to people, would you like to live here? This is something that's been advertised by an estate agent and people have registered their interest in the way that you would normally do. So that goes to the matter of professional integrity on it as well.
And just to add on that as well, and I think they categorise them into serious they have a categorisation system, so they have evaluated the seriousness of the expression of interest.
We'll come to section 11 of the framework when we're looking at the next topic on the agenda, I think. Yeah.
There's lots of places that I could go to in the MPPF, but I don't think it's important that we have to dwell too much upon them. But we've certainly got the range of types of houses meeting particular needs. We know that national government, it's in the Statement of Common Ground, is seeking to encourage this type of development. We know that the MPPF talks about the importance of small and medium-sized sites at paragraph 69. We also know that there's references to housing in rural areas and how they could contribute to sustainable communities. And there's also the general point on transport that there's a recognition, I think it's about paragraph 103. No. That in rural areas, traffic behaviour, transport behaviour might be slightly different because you wouldn't have the opportunities to have the same public transport and so on, but that's something that's acknowledged. Sorry, that's 105.
Thank you. So obviously, I think you both in your evidence you've referred to the Helpston, is that right? Helpston garden centre decision. I'm not intending to sort of delve into
No, I'm satisfied that most things have been covered there. Thank you.
thank you. So Sorry about that. I forgot to put my microphone back on. Oh, that's fine. So bearing in mind policy LP16's requirements, does any part of the local plan support or prohibit the development of this particular site at the density that's actually proposed? Because the development that I know the council has concerns about the density in terms of affordable housing threshold, but at the end of the day, the development which is before me is up to 14 homes, so that's what I'm considering. Is there anything in the remainder of the plan? Because I've obviously got the policies that I've been told what the most relevant policies are, and I've been given, and I don't go and I'm not
Looking
allowed to go
elsewhere.
and delve
No.
for more policies.
I wouldn't expect you to have an inquisitorial role at all. It's LP16, paragraph B, which is most appropriate. But you're right, man. There are no other policies elsewhere in the local plan which provide minimum density requirements.
Can you
for
just
it.
read that out to me, what that is? Because I haven't got it in front
Yeah,
of me.
so policy LP16 design in the public realm, all development proposals are expected to positively contribute to the character and local distinctiveness of the area and create a sense of place. As such, and where applicable, proposals will be required to demonstrate to a degree proportionate to the proposal that they, and then it's A down to I, and B reads, B, make effective and efficient use of land and buildings through the arrangement of development plots and the design, layout and orientation of buildings on site.
But it doesn't specify a density.
It doesn't specify minimum density, and you don't find that in this local plan.
Yeah. Is there anything that you want to say on that? It was more
Just
point
in terms
of clarity.
of, is there a requirement? No, there's no minimum
okay.
requirement.
So just setting aside the affordable housing concerns at the moment, and I'm just wanting to explore a little bit more, understand from the council's perspective, what are the implications, if any, of developing at the density that's proposed. So I know that it means that it's under the threshold for affordable, and that's, but I'm not.
I mean, essentially,
so it's the harm. It's really what's again.
What's
it's
the
like
harm?
It's what's the harm
Yeah.
of.
So, ma'am, if you were minded to, go with the appellant's case that the self-build and prestige nature of this development proposal would allow an exception to be made from the restrictions in policy LP2, if you were minded to adopt that approach, the council's concern is that allowing so few affordable and prestige self-build and prestige dwellings on this site, allowing so few would mean that same policy exception would need to be applied elsewhere potentially to deliver further prestige and self-built dwellings, which according to the appellant there is significant demand for.
So what density are you generally finding these, like on sites of 500 and plus where you're delivering self-built prestige? Is there evidence around the density?
I think it would be helpful to have drawing 01A in front of you.
I've got it.
Or maybe 12A, either one,
Yeah.
whichever is the bigger scale. I can't.
Disappeared too now. I had both of them, but yeah, right. I've got 12.
Okay, so just with reference to that drawing, our experience on the self-built plots on our urban extensions are that the dwellings are more akin to those at plots 13 and 14, which are the two detached properties to the immediate right-hand side of the development access shown in that drawing.
Okay.
And that's the nature, size and land take of prestige and self-built homes which we are seeing coming forward on our urban extensions. And those are very distinct from the significantly more land-hungry plots to the left-hand side of the axis.
Okay. But in terms of this particular, what would be the harm on this particular site being developed
At the density proposed.
at the density that's proposed?
Yes. It's more that it could be developed at a higher density without causing any additional harm on site itself. So not quite the question that you've asked.
No, it's not.
I appreciate, but that's the answer which I'm giving, I'm afraid.
Would you like to say anything?
Yeah, I'm not sure whether I should have hit the last opportunity, but when we were dealing with the policy, the one aspect of the policy that we've skipped right over is the fact that we've also got to have regard to the context of the site. And part A of that policy talks about respecting context, talks about the local patterns of development, including spaces between buildings, and it even refers to the word density there as well. This is all in line also with national policy in paragraph 124A and D, which are talking about the particular identified needs of the type of housing in A, and then in D, it's talking about the desirability of maintaining an area's prevailing character and setting. If I could just jump to the SPD document that you referred to earlier, Ma'am.
Yeah.
And it's page 51.
Do you want me
Do you
to
have
have
that?
that in front? Do I need?
I
need it in front of us, or?
I could read it, and
Yeah,
if you think
yeah,
it's a point
yeah,
that you
yeah,
need to go back
yeah.
to, these are design guidelines for those parts of the village which are outside the conservation area, and there's
Yeah.
two in particular. It's WAN 14 and WAN 15.
Yeah.
And what it's talking about here is how gaps between buildings are of utmost importance in maintaining the feeling of spaciousness that is an important characteristic of Wansford. 15 is also talking about the need to avoid a hard edge to the village contour and how that's got to be avoided. So just trying to put density in the context of the scheme that we're dealing with, you have to have regard to these wider considerations, and it's not simply a matter of saying we should be developing at 35 to 1 spec to 30, 20, or a specific figure. It's a response to the site. And if you, as you will, look around the village, you'll see this through aerial photographs, and you'll see it as you walk through the village. It would be in keeping with the character of the village.
And that's something one of the good things about a site inspection is that I can put everything that I've heard into and arrive at a view as to.
The other issue as well, when you come to prestige homes and bespoke self-build units, is not having the situation where you sometimes see on schemes where a plot of land has been put aside and everybody's had to cram their individual design into place. It kind of gives a bit of separation between units, gives flexibility of plot plans, and not saying that all units have got to be orientated in the same way and such like. So it gives that flexibility later on. And as with all of these things, reserve matters is something that would be in the council's control, and they could deal with layout, and in part that's going to deal with density as well.
So if this had been a scheme, what is the in the council's opinion, what is the appropriate density? Is there a density that you have in mind that
there isn't, ma'am, no. And I think if we go maybe back to the local plan process when the site was promoted for residential development, the council could not come to a density where it considered this scheme, this site could come forward for housing without causing harm to character and appearance.
Okay. So basically, it wasn't a. The council's opinion doesn't necessarily turn just on density. There's other things that are in play.
It's the wider basket,
yeah,
correct?
That's fine. I get that. Is there anything that you want to say?
No, I don't think so. I think that there's always a danger of saying just because a site wasn't allocated, that means that you could never build on that land again, because we wouldn't be building on lots of greenfield sites that we currently are if that was the case. This is a particular proposal that's now in front of you as part of an application.
Yeah, no, that's fine. Okay. So that's all the questions I've got on density in its purest terms. Obviously, we might come back to it when we're talking about character and appearance. It'll creep in, but it just is in its trying to deal with it in its purest terms. We're now at 1:45. Where we are. Right. Well, I was actually, the way that I had worked things out, I had been hoping to get to through local housing needs and then break for lunch. Now I had been thinking, but lunch was going to be about this time. I'll just check to see how many questions I've got. Got quite there's a few questions on that, so I'm wondering whether it might be best to break, if we break for lunch now, and then could we do 45 minutes, like come back for 1:30, maybe 1:30, have a short lunch, and then that'll help other people as well that are, so they're not waiting around for a whole hour. Would that give you enough time as well? And then that would get us to probably where we need to, where I was hoping to be at. So what we'll do is, it's now 10 to 1, and we will adjourn now, and we'll resume at 1:30. So thank you very much. Thank you.
On your timetable, are you envisaging it will go to 5:30 on it? The reason being, I've got my mum looking after my kids in Manchester, so I just want to let them know if I'm going to be back for bedtime.
The only thing that's worrying me is the land supply, and it depends on how.
Understood. But we're going to use most of that time, aren't we? So I better send
I think if I would, I wouldn't want you getting a speeding ticket or
I'm on the train, so
of our children being abandoned.
No, I just exactly that. I just want to know what I can say. I'll say I might be back.
Yeah. Sometimes, I mean, sometimes I feel as if it.
Yeah, no, I totally understand.
Yeah.
Because I don't know how many questions you have, but I can see that's the way it's heading. So,
Thank you.
No, thank you.